If the community denies a permit for a proposed development because it does not satisfy the requirements of its floodplain management regulations, the applicant has the option of requesting relief or exception from the requirements of those regulations. This is known as requesting a variance. In this video, we will describe the variance process and considerations for when a variance should and should not be granted by a local community. These key terms and acronyms will be used during this presentation. You can find the terms and their definitions at the web address on screen. Each community has in place a board whose responsibility it is to review requests for variance. A property owner wishing to request a variance must submit their application to the local floodplain manager, who will forward it to the board and schedule a public hearing on the application. At the hearing, the property owner will be given an opportunity to present their case for why they believe the project should not be required to satisfy the requirements of the floodplain ordinance. Individuals with an interest in the outcome of the process, such as the local floodplain management official, owners of neighboring properties, city or county engineers, or others, are also given an opportunity to present their views and information. The board then considers all the testimony and materials submitted during the hearing and makes a decision as to whether the property owner sufficiently justified the granting of a variance for their proposed development. The community's floodplain management regulations include criteria that must be considered when deciding whether or not to grant a variance. Among those criteria are a showing of good and sufficient cause, a determination that failure to grant the variance would result in exceptional hardship to the applicant, and a determination that the variance is the minimum necessary considering the flood hazard to afford relief. The community's floodplain management regulations do not anticipate every imaginable situation, and so the variance process allows an applicant to request an exception for a unique situation. However, the variance must pertain to the land itself, not to the structure, its inhabitants, or the property owner, and should not be granted for an issue that can be resolved through other means, even if the alternative is more expensive. A variance should only be granted in situations where a property has physical characteristics so unusual that complying with the ordinance would create an exceptional hardship on the applicant. Those characteristics should be unique to that property and not be shared by adjacent parcels. Otherwise, similarly situated properties would also be eligible for a variance, which defeats the purpose of the community's floodplain management ordinance. Again, the unique characteristics must pertain to the land itself, not the structure, its inhabitants, or the property owner. The hardship that will result from failure to grant the requested variance must be exceptional, unusual, and peculiar to the property involved. Economic or financial hardship, inconvenience, aesthetics, physical handicaps, or personal preferences cannot, as a rule, qualify as exceptional hardships. A variance should be a request to vary from the requirements of the community's floodplain ordinance, not to ignore them. For this reason, any variance granted should allow only the minimum necessary deviation from the normal requirements. In the case of a request for a variance from building elevation requirements, this would mean that the variance would not grant permission to construct the lowest floor at grade, but to the level that both provides relief for the applicant while still preserving the integrity of the floodplain ordinance. There are additional considerations associated with variance requests for development located in the floodway. Variances should not be granted for any development within the floodway that would result in any increase in the elevation for the base flood event. Unusual and peculiar physical characteristics of a property may provide instances under which a local community could justify granting a variance request. Some of those physical characteristics of a property may include an irregularly shaped lot, a parcel with unstable soils, or a parcel with unusual geologic conditions below ground. The following are examples of when a variance from the building elevation requirements would not be justified. When the property owner cannot afford to comply with the regulations. When the elevated building will look different from the others in the neighborhood, or when the owner cannot climb up steps into an elevated building or addition. A variance granted by a community from the building elevation requirements of its floodplain ordinance will not affect the methods used to determine flood insurance rates. And the increased risk associated with a non-compliant structure will be reflected in higher annual flood insurance premiums. For this reason, whenever the community grants a variance from the normal building elevation requirements, it should inform the property owner that the building will be subject to increased flood insurance rates that could potentially be as high as $25 per $100 in coverage. The granting of variances from the community's floodplain ordinance should be a rare occurrence. If FEMA discovers that a community is routinely granting variances that are inconsistent with the objectives of its floodplain ordinance and the NFIP, the community can be subject to probation or suspension from the NFIP. Today, you have learned about the process for seeking variances from local floodplain regulations and considerations for when a variance should be granted by a local community.